PhD at the University of Supervision on doctors. Next up we have Jasmin Johurun and Nessa, who is one of our own PhD candidates at the University of Vancouver. Her PhD focused specifically on state practice in order to examine the evidentiary standard of self-defense in international law. She also teaches public law 1 and 2 at Sina. And finally, from Monash University in Australia, we have Sina Etezazian, who is completing a PhD there on the duties of the exercise of self-defense under the supervision of So, 15 minutes. Okay. First off, we'll start.
Thanks, Henry, and thanks to Patrick and Ben for organising what's been a really great conference so far. So in my research, I argued that the United States targeted killing program is indicative of the return of the doctrines of Kriegsraison and self-preservation to international law. And there are many aspects of the targeted killing program which demonstrate this, but I'm going to focus on 2 aspects today. So firstly, how drones themselves have been presented as exceptional, and then secondly, how the US is interpreting self-defense and imminence in the context of the program. And before I discuss this, I'll just give a very short overview of the targeted killing program. I discussed this yesterday as well, so you kind of are probably a bit familiar with it already. And then I will explain what Kriegsraison and self-preservation actually are. So the United States started their targeted killing program in 2002 during the Bush administration, but it was used pretty sparingly until 2009 when we have Obama really started to like industrialize the program, I think. It's still very secretive. It wasn't actually officially acknowledged until 2012. So accurate figures on the number of civilian and militant deaths are quite hard to come by. The Bureau of Investigative Journalism is just one of the organizations that looks at counting the dead. And they estimate that in Somalia, Pakistan, and Yemen, there's between 3,200 and 5,200 deaths since then. So what is Kriegsraison? So it means reason of war, and it's this 19th century German military doctrine in which the necessities of war take precedence over the rules of war. And the doctrine maintains that belligerents may do whatever they feel necessary to prevail in an armed conflict. So it's essentially the unlimited application of the concept of military necessity, and it emphasizes the exceptional character of a conflict or a situation in order to breach the law. And Kriegsraison reached its zenith during World War II, but it was never particularly widely accepted. And it's explicitly referred to in the 1987 commentary on the additional protocols of the Geneva Conventions, which states that resort to the doctrine was likely based on contempt for the law, and that the doctrine should be considered discredited. Walter writes a lot on Kriegsraison as well, and he actually states that Kriegsraison needn't necessarily be just about military necessity at all, and rather it's a way of speaking in code or a hyperbolical way of speaking about probability and risk. And nor does Kriegsraison justify doing only whatever is necessary to win a war. It also justifies whatever is necessary to reduce the risks of losing, or simply to reduce losses or the likelihood of losses in the course of the war. So the targeted killing program is certainly guilty of speaking in this hyperbolical way, and it's also repeatedly justified in the context of reducing the risks of losing the war on terror and of reducing losses in the course of the conflict. And so this is why I think a focus on how drones themselves have been presented as exceptional and as cost-effective, humane and precise demands examination, because this construction is central to portrayals of the targeted killing program itself as exceptional, and it enables the US to wave away a lot of concerns regarding the legality of the strikes. So then self-preservation. So just as the doctrine of Kriegsraison was invoked to justify the unlimited application of military necessity, the doctrine of self-preservation allows for recourse to force for any reason related to the preservation of the security of the state. So it can be considered a specific application of the broader concept of necessity, with anything necessary for the state's security warranting the use of force. So while it's closely related to our modern conception of self-defense, and indeed the terms self-preservation and self-defense were actually used interchangeably up until the early 20th century, they're actually considerably different. So in the self-preservation doctrine, it's believed that states have a fundamental right to self-preservation, which supersedes their international obligations and the rights of other states, such as the right to territorial integrity. So if the argument for a right of self-preservation is followed to its conclusion, any conduct deemed necessary by a state to ensure the preservation of its existence was bound to be considered juridically legitimate, even if it was undeniably contrary to an international obligation of that state. So self-preservation really cloaks with an appearance of legality any unwarranted act of violence on the part of the state. And the US's expansive interpretations of the right of self-defense and of imminence proffered a justification for the targeted killing program really push our understanding of self-defense closer and closer back to the doctrine of self-preservation. So I'll just discuss now how the hyperbolical use of language we see in Kriegsraison has been applied to drones. And a focus has been placed on each of the three aspects I addressed because they fit this narrative of reducing losses. So the first is cost effectiveness. So in economic terms, drones widely been touted as a far cheaper and more efficient alternative to manned aircraft. And indeed, the Congressional Research Service itself has stated that drones are the poor man's Air Force. However, a 2012 report by the American Security Project concluded that drones have only a slight cost advantage over fighter jets, with drones far more prone to mishaps and requiring far more personnel to operate. And then we also have to add to the actual operational costs and the cost it takes to develop drones, the hundreds of millions of dollars that the Department of Defense is now spending every year just on private contractors to analyze the hundreds of thousands of hours of footage that are coming in from drones every day. So arguments regarding cost effectiveness, the thing is they've never actually really been about money, as much as they are about human and political cost. And it should be noted that the targeted killing program is extremely politically popular on both sides of the House in the US. It's one of the rare things in which there is bipartisan agreement. So as Parks CAG note, if we look at the rhetoric surrounding the development of combat drones, much of it turns on troop protection and the ability to project force without risk. So the life-saving aspect of drone strikes is consistently put forward in their support. And this life-saving rhetoric tends to have two components. And the first is that drones save the lives of American military personnel, as there's no need to have boots on the ground in the territory in which the strikes take place. And then the second is that drones spare more civilian lives relative to other forms of aerial bombing due to their precision. And that's something that I'll address in a few minutes. And the idea of the drone as humane technology has been embraced by proponents of the targeted killing program. And drones save lives is a repeated refrain. So for example, in 2010, we had Ken Anderson write that drones are a major step forward in humanitarian weapons technology. In a 2013 interview, we have Senator Angus King said that he believes that drones are a more humane weapon than usually used in conflict. And an article in The Atlantic in the same year was headlined, "Drones actually the most humane form of warfare ever." So how a weapon such as the Reaper, described by the US Air Force as a hunter-killer with onboard hard kill capability, can be described as humane, certainly seems oxymoronic. Anais explains that to call a weapon humane is to imbue it with compassion and benevolence and to suggest that it involves the least possible infliction of pain. So the imputation of humanity to the weapon itself loops around to invest its user with an air of civility. So describing a weapon as humane really serves to make the state using it appear humane in their actions and their decisions. So while a drone strike might be considered humane for US troops and policymakers who are in no danger of being the target of one, it's rather less humane if you are on the receiving end of a drone strike. And of course, a drone is no more humane than any other kind of weapon. And as Heather Linebaugh, who's a former member of the US Air Force, she worked as a geospatial analyst for the drone programs in Iraq and Afghanistan, has noted, UAVs are used as a weapon, not for protection. And it's not a coincidence that this turn towards humanitarian warfare has occurred as populations, particularly in the West, become more reluctant to go to war. So in order to have populations support their state's involvement in a conflict, politicians often now need to assure their citizens that conflicts and the ways in which they are fought will be humane. And what else can convince us that weapons are humane? And this is where precision really comes into play. So claims of precision are central to the representation of drone warfare as ethical, superior, and exceptional. We have former Defense Secretary Leon Panetta, who claims that drones are probably the most precise weapons in the history of warfare. Anderson again states that drones allow for increased discrimination and targeting, not available via any other comparable platform. But recent evidence shows not only that the White House has been deeply misleading about the precision of drone strikes, but also that drone strikes in non-battlefield settings, such as Pakistan, Yemen, and Somalia, are roughly 35 times more likely to cause a civilian fatality than an airstrike by a manned aircraft in a conventional battlefield setting. So drones actually result in far more civilian fatalities per each bomb dropped. And what does precision actually mean? So terms such as precision-guided munitions or precise weapon, under current US military definitions, mean only that the weapon in question is one that is expected 50% of the time to hit within 3 meters of the aim point. And precision has no meaning other than this. Precise and precision don't indicate that the correct person or group has been targeted, and the meaning of precision has been deliberately conflated with the idea that because the weapon is precise, it's also killing the right people. And in this way, terms like target and precise actually conceal a lot more than they explain. So these unqualified claims of cost effectiveness and precision work directly with notions of weapon platforms as humane to make uses of force more legitimate and justifiable, and to make resort to war both more politically acceptable and politically viable. So for targeted killing, the concepts of precision, cost effectiveness, and humanity work in concert to reify the idea of the armed drone as an exceptional weapon. And if the war on terror is exceptional in its nature, and if all individuals targeted represent exceptional imminent threats, then an exceptional tool should or indeed must be used to fight it. And this now brings me to the US interpretations of self-defense and imminence. So justifications for the targeted killing program rely on the notion of preventive or preemptive self-defense. So under Article 51, as you know, states have the right to use force in self-defense, and it's fairly widely accepted now that an anticipatory right to self-defense also exists. So if a threat is imminent, if someone's about to launch a strike or an attack, you are allowed to use force in self-defense. The interpretation that the US uses is this interpretation more preemptive or preventive self-defense. So under this interpretation, when a state believes that a threat to their national security exists or that a threat will exist, it can use force in self-defense against that threat, even if it's not even an actual threat or something that's actually going to happen in the short or even possibly long term. So any preventive action taken here is deliberately future oriented and thus actually loses its defensive character. And it's here that the idea of imminence really becomes important. So traditionally our concept of imminence aligns with the Caroline doctrine. So the threat should be instant and overwhelming, leaving no choice of means and no moment for deliberation. But the US interpretation of imminence has been variously described as used in a way that deprives the word of its ordinary meaning, woefully overbroad, and as expanding the concept beyond recognition. So for proponents of the targeted killing program, imminence acquires a unique elasticity, particularly with the introduction of the concept of a continuing imminent threat. And the supposition that a threat can be both continuing and imminent allows the state to have recourse to force at any time it sees fit. Such continuously imminent threats represent those threats which are allegedly combated by the targeted killing program. And it's through the targeted killing program that imminence has acquired this new and ultra-flexible character. And the most detailed discussion of imminence that we've seen from the US to date comes from a Department of Justice white paper that was leaked by NBC News. And the section in this white paper says that the condition that an operational leader presents an imminent threat of violent attack against the United States does not require the United States to have clear evidence that a specific attack on US persons and interests will take place in the immediate future. And it's quite clear that this expression of imminence is problematic. So what this definition boils down to is that it's possible to target a US or other citizen at almost any time in any place, no matter whether an attack on US persons or interests is shortly to occur, once the US believes that the threat exists to their national security. So in short, it's not really preventive self-defense that we're seeing here, it's actually the doctrine of self-preservation. And this Kriegsraison and self-preservation based reasoning is now pervasive in the US and in counter-terror measures, but have other states ascribed to such views? I think there's an argument to be made that the UK is certainly on its way to doing so. The Secretary of State for Defence has asserted that where the UK uses lethal force outside of armed conflict, it will comply with the laws of war, and that this compliance will be sufficient to meet the UK's obligations under human rights law. However, as the Joint Committee on Human Rights has stated, the effect of that assertion is that the UK government's policy ends up in the same place as the US policy, despite disavowing the wide American view of the existence of a non-international armed conflict. And it's the same with their conception of imminence. So if you consider strikes on Riyadh Khan and Rahul Amin in August of last year, and because of the threat of an imminent attack, the attacks that were actually discussed by the government were due to take place in May and June of that year, never came to fruition, and it turns out that their names have been placed on the list in spring of that year, so it doesn't seem particularly immediate or imminent. I think we see this kind of Kriegsraison reasoning creeping into a lot of Russian actions as well, particularly if you look at the language around Ukraine and Crimea. So we have Russian Foreign Minister Lavrov describing Crimea as a very special case. But I think what's really interesting is that Putin himself, in a speech justifying their actions, has stated that our Western partners, led by the United States of America, prefer not to be guided by international law in their practical policies, but by the rule of the gun. They have come to believe in their own exclusivity and exceptionalism. And this seems to be proffered not just as a way to hit it at the West, but also as an excuse to validate Russia's own actions in the territory. So despite protestations from the states mentioned above, and of course other states I don't have time to discuss, but their actions abide by international law, we're actually experiencing a return to the time when Kriegsraison and self-preservation offer themselves as justification for sometimes irresponsible, often predatory, and very often unjustified state behaviour. And like I said, this Kriegsraison-based reasoning is now really pervasive. While it's possible for a state to evoke Kriegsraison during an otherwise lawful conflict, where a state has justified their recourse to force to ensure the security of their nation, it's likely that Kriegsraison will occur. So both doctrines emphasise the exceptional character of the conflict in order to breach the law. Both allow for any necessary means to be used in furtherance of their ultimate objective. And I think we'll do well to keep in mind in all discussions on the targeted killing programme, another comment made in relation to the 1987 Geneva Commentary: law is a restraint that cannot be confused with more usages to be applied when convenient.
So we move on to Jasmin, who presents a paper on the right to self-defense in facing modern terrorism and looking at. Take it away, Jasmin.
So hello, my name is Jasmin. I'm doing my PhD here at the University of Liverpool. So for my thesis, I'm looking at what the evidentiary, or if there is an evidentiary standard for self-defense in international law. We have many states now, or in recent times we have even more states now invoking their rights of self-defense, yet they don't have a single evidentiary standard of proof to refer back to say, this is a standard of proof that we've met to have a valid claim on self-defense. So that's what my PhD is looking at. What I started off doing this year, in my first year, is just looking generally at the parameters of self-defense. And I think at the moment, the most controversial issue with self-defense is, or one of the most controversial issues with self-defense, is this, whether it can be invoked against a non-state actor, such as Daesh and the threat from Daesh at the moment. So what I'll do is, if I can categorize self-defense, or the way it can be invoked in three parts. So traditionally, in this first category, we see self-defense against one state versus another state. So it's just one country against another country, and that's traditionally the framework that self-defense has been seen. But also more commonly, it's also accepted in this second framework of state versus a non-state actor that's attributed to another state. So we're still kind of seeing it remain within the state versus state framework. So even though we have a non-state actor, it must be attributed to another state. And what I mean by attributed is, according to the ICJ, the International Court of Justice, is that the non-state actor must be fully controlled or effectively controlled by a state. So, for example, we have when Israel claimed self-defense against the non-state actor Hezbollah and said that they were attributed to Lebanon. So that's kind of accepted. Now, it's this third category that causes the controversy. This third category of whether we can have self-defense when it's state versus a standalone non-state actor. And that's basically what my paper will be attempting to address today. And I'll specifically be looking at Daesh. So if we start by looking at the jurisprudence coming from the International Court of Justice, in 2004, in their advisory opinion of the war, the ICJ plainly stated that Article 51, the right of self-defense, can only be applied, and I quote, in the case of an armed attack by one state against another state. So that's the first category that I was talking about. So that's generally accepted. We've said that. But we see this similar logic in their 2005 judgment in Uganda Democratic Republic of the Congo, where the court talks about the attacks in that case not being attributed to the DRC. So it's this attribution standard that seems to be the key factor. And what we see here is that the court seems to be trying to keep self-defense within this framework of states versus this state versus state type of scenario. But what I'm going to argue in this paper is that perhaps this position has now been superseded by recent events and the rise of Daesh. So if we go back to 2014, that's when Iraq requested the assistance of the international community in fighting Daesh and the threat from Daesh on Iraqi territory. Now, in response to that, the US-led coalition was established. Now, the legal basis for using force in Iraq is pretty straightforward. They invited states in, they provided consent, so it's just intervention by invitation. Now, what's important is that this intervention by invitation does not extend to combating Daesh on Syrian territory. So prior to the Paris attacks, though, we still had a number of states who extended their military operations from Iraq into Syria. So we had US, we had Australia, France, Turkey, and they all claimed that they could do this because they had the right of self-defense under Article 51. Now, the international reaction to that was fairly mixed. There were, I would say, two issues that with states getting involved in Syria. Number one, Syria did not have full or effective control over Daesh on their territory. So this standard by the ICJ, that criteria was not met. And number two, Syria were not giving consent for the US-led coalition to fight Daesh on their territory. I think, in fact, they specifically said that it would be unlawful under international law if that were to happen, which it did. So after the Paris attacks, the UN Security Council passed resolution or adopted resolution 2249. Now, this resolution has been fiercely adopted because some argue that this resolution authorizes the use of force pursuant to Article 51 and the right of self-defense against Daesh. So if we look at the wording of the resolution, it does appear to start off by using language that is frequently used when the UN Security Council authorized force. So it starts off by determining that Daesh constitutes a global and unprecedented threat to international peace and security. However, if we continue to read, the resolution doesn't actually use the term authorize, as it usually does when it authorizes force, but instead what it does is it calls upon member states and quote to take all necessary measures. Now, I think the correct interpretation for this is not that resolution 2249 automatically authorizes the use of force against Daesh, but what it does say, it uses the term all necessary measures. So if we have a state that is using force against Daesh and they are claiming that it's self-defense, if they can show that it is classed as a necessary measure, then surely that would be a legitimate claim and it would come under Resolution 2249 because all necessary measures clearly would include all, including the use of force. So after this resolution was passed, the UK on 3rd of December 2015 wrote to the Security Council and said that they would be extending their military operations from Iraq into Syria. And they said the legal basis for that was collective self-defense for Iraq and also individual self-defense. They also relied heavily on Resolution 2249 and said that self-defense was called for by the Council in Resolution 2249. So clearly they thought that the UK thought that Resolution 2249 was some sort of authority for self-defense. Now, interestingly, in the UK letter, they seem to be limiting their Article 51 invocation of self-defense to targeting Daesh on Syrian territory only. And that, I think, has important implications. Because, for example, what if Daesh gains strongholds in a different state? Or do we then have to wait for another Security Council resolution to then determine again that yes, Daesh still constitutes an unprecedented threat to international peace and security, and we still must combat Daesh? So really what needs to be addressed is, does this invocation of self-defense extend to fighting Daesh beyond the borders of Syria? So are we saying that we have a claim of self-defense against Daesh in Syria, or are we saying that we have a claim of self-defense against Daesh? They are two completely different things. I would argue that if we accept that we have a claim of self-defense, or we can invoke self-defense against a standalone actor such as Daesh, then that claim of self-defense should be valid until the threat of Daesh is eliminated, regardless of any movements that Daesh make across territorial borders. Because the claim of Daesh, well, sorry, the claim of self-defense is against Daesh, and it should be one that can transcend borders. So a week after the UK joined the fight against Daesh in Syria, Germany basically wrote to the Security Council and said that they would be doing the same thing. Germany also invoked their rights of collective self-defense, and they also relied on Resolution 2249. Now, I like the letter from Germany because at least they tried to they at least attempted to address the fact that Syria were clearly not giving consent for states to come onto their territory to use force against Daesh. So Germany claimed that they can still justify the use of force in Syria even without the consent of the government of Syria, because Syria, quote, does not at this time exercise effective control over parts of Syrian territory. So some commentators have interpreted this letter as Germany alluding to this unable or unwilling test, which is based on the principle of necessity. So if we apply the test, we're basically saying that if Syria are unable or unwilling to deal with the non-state actor Daesh on their territory, then it becomes necessary for us to use force against Daesh on Syrian territory. And we can take this unable or unwilling test a little bit further into the hypothetical. So if Daesh go into other states and the other states do not provide consent, we can still use force against Daesh on their territory if those states are unable or unwilling to deal with the threat of Daesh on their territory. That's one interpretation of the lesson from Germany, which I'm not entirely convinced that they were referring to, well, you could say that they are referring to the unable parts of the unable or unwilling test. But, so the German letter, remember, said that we can justify going into Syria even without the consent of Syria because Syria do not exercise effective control. That, to me, leaves open the question as to if they are using the unable or unwilling test, why not use the specific words of unable or unwilling? I think a more convincing explanation of the choice of words adopted in the letter from Germany would suggest that the deliberate reference to effective control indicates that Germany clearly recognised that Daesh are not attributed to Syria, so this is going back to the ICJ standard of effective control, yet despite this lack of attribution to a state, Germany still believe that self-defense, pursuant to Article 51, can be invoked against a standalone non-state actor. And if this interpretation is correct, I think it's an incredible departure from ICJ jurisprudence. So in January, we also had Denmark, who wrote to the UN Security Council and said that they would be doing the same thing. They would be taking measures against Daesh in Syria. They also relied on Resolution 2249 and collective self-defense. The Netherlands did the same thing. Interestingly, the Netherlands did previously say that they would not extend their military operations from Iraq into Syria unless they had a clear Security Council mandate. So clearly the passing of Resolution 2249 is the path for the Netherlands to join the airstrikes in Syria. The UAE on 7th of February said that they were ready to send troops, and NATO said that it was considering joining the US-led coalition also. I think in conclusion, what we can say is that none of the states concerned have made an attempt to formulate a claim of self-defense against Daesh in purely interstate terms. Neither have they recognized Daesh as a state, and nor has it been argued that Daesh's violence is attributed to Syria or any particular state. Yet, despite all this, we still have states claiming or invoking their rights of self-defense self-defense against Daesh. I think if the war case in the DRC case came again in front of the ICJ, I don't think they would, in such strong terms, repeat that self-defense is only reserved for interstate conflicts. I think we have now, or we are at least moving away from any norm that absolutely prohibits the claim of self-defense against a non-state threat.
So we move on to our final paper, which is presented by Sina Etezazian from Monash University in Australia. And this paper is entitled The Use of Military Drones in Pakistan and Use of Bellum, Proportionality, Reprisal for Self-Defense.
Thank you. Hello everyone. In this talk, I'll discuss the United States drone strikes taking place in Pakistan in the context of the right of self-defense, paying special attention to the notion of armed reprisal, as well as use of the proportionality. The United States carried out its first drone strikes in Pakistan on the 18th of June 2004, which left one alleged Taliban militant dead along with 4 other fighters. Since then, the US has targeted suspected terrorists based in Pakistan territory, with the latest drone attack killing a Taliban leader on 22nd of May 2016. However, supposing that permissible self-defense includes action against irregular troops or non-state actors, might the US drone activities in Pakistan satisfy the halting and repelling requirement, which serves as the only primary benchmark for the application of proportionate self-defense? Would the targeted killings of terrorist suspects in Pakistan, which have met with denunciation from Pakistani officials since 2013, constitute acts of armed reprisal in violation of the general ban now existing on resort to force? So I'm going to start by talking about the meaning and scope of armed reprisal under the contemporary use at law. I'll then discuss the argument for the revival of the lawfulness of armed reprisal under international law, as well as the opposing argument. And then I'll also discuss how proportionality acts as one of the major legal criteria by which an illegal act of reprisal can be distinguished from an action lawfully undertaken in self-defense. And lastly, I conclude whether a US drone campaign in Pakistan finds its basis in the doctrine of self-defense or armed reprisal. So it's worth emphasizing at the beginning that the distinction must be drawn between armed reprisals, as addressed in this talk, and what are commonly referred to as belligerent reprisals. Belligerent reprisals are coercive measures taken during a situation of an armed conflict by a belligerent party in response to a prior violation of international law by the other. An armed reprisal, in contrast, is resorted to during peacetime, not wartime, and constitutes a forcible response following short of war to a prior breach of international legal obligation owed to the responding state. The unlawfulness of armed reprisals has been emphasized by numerous resolutions of the Security Council, a traditional example of which is a resolution adopted regarding the British aerial raid in Yemen in 1964, in which the Security Council condemned armed reprisals as incompatible with the purposes and principles of the United Nations. The illegality of armed reprisals was likewise illustrated by the General Assembly in the 1970 Friendly Relations Declarations and the 1981 Declaration on the Inadmissibility of Intervention and Interference in the Internal Affairs of the States. In a similar way, the majority of legal experts have argued that armed reprisals are unlawful and actually outlawed. under the Charter of the United Nations, a view that was reinforced by the International Law Commission when preparing the articles on a state's responsibility. Ultimately, it appears that the International Court of Justice, ICJ, in its nuclear weapons advisory opinion, was persuaded that reprisals involving the use of force would be inconsistent with the modern use of law. So despite the absolute prohibition of reprisals in international law since the adoption of the UN Charter, some legal commentators have asserted that they are not entirely banned under the Charter regime. Derek Bowen, for example, suggests that a clear disparity between the actual practice of the states and the formal rules prohibiting armed reprisals can be observed. And moreover, he stresses the Security Council's failure to condemn all reprisals as unlawful, which defines question if the principle is that all reprisals are illegal. However, the failure to condemn several unilateral actions that could be linked to armed reprisals hardly serves to present a strong argument for the legality of reprisals under the Charter regime. As Olivier Corden, for example, has made clear, a review of discussion within the Security Council reveals that the absence of condemnation is explained essentially for reasons of alliance or political opportunity. More importantly, the assertion that armed reprisals are not contrary to international law under certain circumstances runs up against considerable position based on the lack of opinion use, with the states almost never justifying their unilateral resort to force as a reprisal. An examination of state practice and corresponding opinion use, such as the United States attack on Libya in 1986, makes it possible to identify that even states using disproportionate and unnecessary force have opted, albeit broadly, to rely on self-defense almost exclusively. Therefore, in the post-Charter era, the main justification for the use of force outside Security Council authorization remains the exercise of the right of self-defense, recognizing Article 1 of the UN Charter and customary international law governing states' forcible action. The difficulty, however, lies in the distinction between armed reprisal and self-defense. This is because both reprisals and self-defense are forcible measures taken in response to the prior unlawful use of force. On a number of occasions, however, the states would seem to have presented a framework of how a legal distinction can be made between armed reprisals and self-defense measures. For example, when the General Assembly's Sixth Committee met to draft the definition of aggression, Guatemala stated that the concept of proportionality was an excellent criterion for determining whether an action was defensive or aggressive. A similar position was further taken by Sweden in relation to the ICJ's nuclear weapons advisory opinion, when Sweden observed that reprisals are disproportionate in comparison with the provocation which preceded them. The significance of proportionality for the determination of the content of armed reprisals was also confirmed by Iran in the oil platforms case, while Congo took a similar approach with regard to Israel's claim of self-defense against Hezbollah in 2006. Finally, in the Security Council meeting held following the 2009 Gaza conflict, Costa Rica stated that Israel's military activities in the Gaza Strip have been disproportionate, highlighting that legitimate self-defense does not sanction reprisals such as those carried out by Israel. In view of the foregoing, state practice appears to support the proposition that at least one of the distinguishing features whereby one can differentiate between a permissible self-defense action and illegal armed reprisals is the disproportionate nature of the latter. So, going back to the case of Pakistan, it is clear that the United States, in the main, has relied upon an inherent right of self-defense to maintain that its use of military drones in pursuit of the war against terrorism may be viewed as satisfying the requirements of the use of law. John Brennan, who has served as Chief Counterterrorism Advisor to US President Barack Obama, asserts that because the United States is involved in an armed conflict with Al-Qaeda, it is permitted to use force against Al-Qaeda and its associated forces without undertaking a separate self-defense assessment each time. However, the United States managed to remove the Taliban regime and install an interim government soon after it invoked self-defense in October 2001 to intervene in Afghanistan. Therefore, even assuming that engaging in coercive measures against the Taliban government could be seen as proportionate self-defense, for example, if it was necessary to effectively respond to Al-Qaeda, the aim of defense has been achieved in the circumstances, which means that a separate series of unilateral actions, at least against the Taliban, had required a separate self-defense justification. Indeed, John Brannan's wide view of defense force appears based upon Johrun Dinstein's theory of the war of self-defense, which contends that there is no support in the practice of the state for the notion that proportionality remains relevant throughout the hostilities in the course of war. According to this theory, once war is lawfully waged, proportionality allows for the coercive measures to be used in self-defense, not only to the point of repelling the attack, but beyond that, to the point where the force used in self-defense could bring about the total defeat of the attacker. However, the proponents of the war of self-defense do not offer any convincing basis in custom international law for their radical assertion regarding the scope of proportionality in situations involving war. Given this, Brannan's argument likewise seems to have weak legal standing in state practice and opinion use. Absent evidence of states' express acceptance of US drone activities in Pakistan as an extension of lawful self-defense, it would thus seem that there is some difficulty with US justification for the employment of drones in Pakistani territory on the basis of Article 51. So a strongest conclusion to draw under current international law is that the US drone activities in Pakistan run afoul of the requirements of proportionate principles. The self-defense justification advanced for the use of force in Pakistan has been predicated on a broad and open-ended invocation of Article 51, which is, in my view, unlikely to accommodate the main demand of proportionality, halting and repelling the attack. Measured according to this criteria, the disproportionate forcible measures that have resulted in the continuing territorial infringement of Pakistan's sovereignty may amount to, I think, acts of reprisal rather than self-defense.
So we have just had three very, very interesting, short, loads of questions on them. So we'll open up the floor to general comments, questions. Yes, Max.
Thanks to all three of you. They were really fascinating papers. Obviously, I'm bound to say that, seeing as it overlaps so much with my research interests, but really great stuff. So I've got a question, if it's okay, I've got a couple. For Catherine, I just wondered, in your opinion, to what extent do you think that this Kriegsraison theory is it being reintroduced, or is it actually being drawn out, as in, like, really, we could argue that it's an inherent part of the jus ad bellum, which is a kind of, if we take Antonius Xenakopoulos' notion from yesterday of international laws being an enabling force, then that perhaps it's an inherent part of jus ad bellum that's merely being emphasized at the moment, but it's always been there. And then I put one for Jasmin. It's about your, I guess maybe it's kind of half a comment, maybe it'll turn into a question. It's to do with these your three views of self-defense and the attribution of a non-state actor to a state. So I was always of the opinion that there needed to be this link in terms of self-defense to argue that there could be an attack, to kind of create a permissive, restrictive regime of the use of force. But I wonder whether you could just comment on the argument that actually in the case, I can't remember which one it is that discusses effective control, that actually the court was not talking about armed attack, they were talking about state responsibility for a breach of international law, and they weren't referring to self-defense. And then in the jurisprudence of the ICJ, in the war case, they do say it has to be state against another state, but that's in the context of not actually discussing self-defense. They specifically then say, don't they, that but we're not going to provide a resolution to this question now. It's kind of almost by the by. And the DRC against Uganda case, admittedly, you do see this attribution requirement there again, but it was such a contested decision with some real critical dissenting judgments. I think the commentary has been that that possibly the customary nature of self-defense, as well as its place within treaty, means that there isn't this attribution requirement, and actually that self-defense has always been kind of open to this standalone non-state actor. I just wonder if you could respond to that, or what your thoughts are on that issue. Sorry, that went on rather longer than I'd hoped.
Yeah, that's a good question. I think that you're right, like to an extent, it has always been there and it is kind of being drawn out, and I think it's definitely a part of this, what you mentioned yesterday about whether we see IHL as protective or permissive. And I think that what we see at the same time, certainly, since the events of 2001, is that there's a real tension between kind of like military necessity, the view of IHL where we call it maybe law of armed conflict instead, and then the humanity thing, and there's a balance there, and there's really a pull. I was at a conference a while ago, and Johrun was like, save the law from the human rights mix. And I think the tension is certainly there, but I think, after, with the Geneva Conventions, it addressed that, or at least sought to address it. I think the doctrine is being reintroduced. I think the possibility for it was always there. It had never really fully gone away, because we do have that tension between military necessity and humanity. But I think that the language for this language of crises that we're seeing, the rhetoric of whatever it takes, so exceptionalism, has brought this more permissive doctrine back in, when after World War II, it was like gone.
Any other questions? Ben?
I'd echo Max's thoughts a little bit really fascinating papers. There were so many questions that probably used it to ask the same questions to all three, because obviously the papers overlap so well. It struck me for a large part of the conversation that the woman and label doctrine seems a little bit in the room, in the sense that I wasn't familiar with the creating a radar doctrine, but it seems like there's many elements that overlap with label and maybe opportunity to expand on that. You think there are big sorts of interactions when you have thoughts on the doctrine. I'd say that woman and label does the fact that Pakistan would seem to be unable to deal with terrorists on their territory change the use of rules in relation to US drones. Also, there's a really interesting question in relation to aspects of proportionality, often European law, not able to do with the necessity elements of self-defense, when the evidence also that it in any way changes the threshold in relation to the use of proportionality. And Jasmin, whilst the one who made the theory tendency into your paper, and I agree with your understanding of the doctrine, seen as though a reliance on unwilling and unable would be essentially the only way that you would justify use of force in Syria, considering I believe the understanding of 224 now. I was wondering if I made thoughts on what it's called legal status is, considering the team like states are relying on it, even if it has yet an example. The same question, I think it relates to it. I think it's a different way.
So just quickly in response to Max's question earlier, I'm of the opinion in terms of the ICJ, I'm of the opinion that they were specifically stating that Article 51 only applies in the case of an armed attack by one state against another state. They did make specific reference to Article 51, and in response to that, in a separate opinion, the judge did say that he didn't agree with that. In terms of Ben's question, unable or unwilling standard, I think the unable or unwilling test is emerging in customary international law and states. And I think it is one that should be emerging facts, because states do have a duty to ensure that their territory is not being used for terrorist activity to then launch armed attacks onto other states. So if they are unable or unwilling to deal with that threat, then I think recourse should be allowed for states that do or that do receive an armed attack.
So actually, I think that since the airstrikes began in Syria in 2014, there has been a developing state practice which points to the admissibility using force against non-state actors, even in the absence of attribution. But I still think that it is not well established. It is not widely accepted in customary international law. So in my backing, actually, returning to my presentation, what I argue is that we assume that the use of drones in Pakistan is admissible because we again assume that the use of force against non-state actors is permitted under international law. So assuming that the use of force, the use of drones in Pakistan is permitted and lawful, so what about proportionality? It is proportionate or not? So what I argue and what I think is that it is not proportionate because, as I said, it doesn't meet the holding and the requirement of proportionality. But why it doesn't meet such requirement is that because it is both temporally and geographically it's very wide. In my view, and based on what I've argued in my thesis so far, which is under revision, I think proportionate self-defense is qualified by some factors, some criteria, which is effects on civilians, as well as the temporal and geographical conditions. So there must be some sort of limitations according to what we can see from state practice since the adoption of the UN in relation to the acts justified on the basis of Article 51.
Can I just make a little comment on the fact that you said that the enable or unwilling test isn't widely accepted? I just find it difficult to see what the legal basis for using armed force against Daesh in Syria would be if we don't kind of invoke the unable or unwilling test, because Syria clearly stated that they do not give consent and it would be against international law. So I think it was yesterday that Belgium basically said that they would be extending their military operations into Syria as well, and they've said that they are doing it on a legal basis is collective self-defense of Iraq. So if it's in collective self-defense of Iraq, but they're using force on a different territory, so they're using force against Daesh in Syria, clearly they're either saying that there's some sort of attribution with Syria, and that's why they don't need the consent of Syria, or they are saying that Syria are unable or unwilling to deal with threats, and that's why they're looking at. Although I do admit the letter, I haven't read it, but I have been told that it hasn't. They don't refer to the unable or unwilling test. I just I find it difficult to understand what their legal basis would be if it's not applied.
There's time for one more question. I think you had your hand up first.
Thank you. Again, for both speakers and following up on the ability test. So the widely accepted, the fact that it's widely accepted, I tend to agree with Sina in the sense that it doesn't mean that 7 or 8 or 9 states have explicitly or implicitly applied the unwilling test, that now all of a sudden it's allowed to law. And it could very well be that it's still a violation of international law, even if 6 or 7 states do it and no other state rejects. So I don't know how exactly that follows up or leads to customary international law. But in regard to unwilling and unable in Syria itself, the Syrian government has not said it never consents to the use of force on its territory. It merely said it needs to be in coordination with at this point, international recognized Syrian government. So in that case, saying that there is absolutely no alternative for other states to be involved in the fight against Daesh on Syrian territory is also perhaps not entirely. Well, I don't know. Could it be a viable alternative? And then finally, just a question: how far do you think the unwilling and unable tests go? Because my supervisor, Professor Harris, at one point said, when the terror attacks in Paris and Belgium happens, many people looked at Monash as like the center of terrorist activities. Does that mean that the Belgian government was then unable to tackle the terrorist threat in Belgium? Therefore, it would allow other states to come in and attack or carry out armed force on Belgian territories. How far do you actually think that this unwilling and unable theory does not open the door, let's say, for armed force?
So in response to Syria not saying that they don't consent to military operations on their state, in I think it was December, President Assad was asked in an interview in the Netherlands whether he would consent, and he specifically stated then that he would say he said that it would be against international law. He said it would be illegal, he used the term illegal, and then it was only a month later that the Netherlands did say that they would be extending their military operations into Syria. In terms of how far the unable or unwilling test goes, I just think if you can, if you can accept that we can invoke a right of self-defense against a standalone non-state actor, then no matter which state it goes, no matter which state that they are in or have strongholds, then if that state is unable or unwilling to deal with that threat, then we should, and as long as all the other requirements of self-defense are satisfied, then you should be able to invoke your right of self-defense, regardless of which state they're in.
So, just want to add to what I was saying in response to your question, Ben. Actually, the United States justified its drone actions outside Afghanistan on the basis of Article 51, but it just relied on unwilling and or unable. It actually does not say something about proportionality. And what I was trying to say is that even if the United States try to justify its action outside Afghanistan, they just try to rely on unwilling or unwilling, saying nothing about usable proportionality. They say something about proportionality, but it's all about proportionality in its use in Bellum sense. So they are just silent on this, and this is the question that they have to answer when they are trying to justify the action outside Afghanistan, saying that this is an act of self-defense. Of course, in my view, and I think this is not the minority view, the use of drones in Yemen and Somalia can be better justified in the context and as a consent, because Yemen and Somalia, as Max prepared, has already argued in his article in the journal, use of force can be probably better explored in the context of intervention or invitation. Both Yemen and Somalia have actually asked the United States to come to their countries and intervene militarily, acting against terrorist bases there, but unlike Yemen and Somalia in Pakistan, that's a different story. At least as recently as 2013, the government of Pakistan has officially rejected the United States using drones against the will of the Pakistani officials. So that can be the main justification, actually the sole justification for using force in Pakistan should be the exercise of self-defense.
Okay, thanks very much. So that brings our panel to a close. So if you'd like to make your way to the social space, down the steps to the right for some refreshments, and we will reconvene here at 2:30. Thanks very much.